My talk is all about the F word, fraud. And we're starting in 1602, 500 years ago, with this handsome fellow. This is Lord Coke, and he once said, rather wryly, fraud abounds these days more than in former times. But his words back then, 500 years ago, are equally true today. Not much has changed. Year on year, fraud gets worse. Ending last year, ending in March 2021, there were 4.6 million recorded fraud offences, and those are only the ones that were detected. The year before that, fraud was up by 24%. And you will all have seen the announcement recently from Rishi Sunak that some £4.3 billion worth of COVID support loans were all written off due to fraud. It's everywhere. It's in the air. But there's still a reticence, as the Court of Appeal said about 2 years ago, to go down the route of fraud. It's the F word. It's a bit taboo to plead it. I'll hopefully change that today. What I'm going to do is do a very brief fraud refresher, talk to you about the requirements when pleading fraud, and briefly touch upon summary disposals in fraud cases. Fraud refresher. It's all photographs, by the way. There's no writing on here. Fraud as a cause of action, as you might know, doesn't exist. It's a rubric to describe a litany of different causes of action: deceit, conspiracy, dishonest assistance. It comes in all shapes and sizes. And Lord Macnaghten said this: it's infinite. It's sometimes audacious and unblushing. It sometimes pays a sort of homage to virtue, and then it can be modest and retiring. It would be honesty itself if it could only afford it. What he's trying to say in those garrulous words is it's easy to identify a fraud case. We see a case, we can pick out something is wrong. Something has happened here that is suspicious, but it's difficult to pin down due to its technical nature. Now, later on, Paul Kerfoot, he'll be talking about bribery, for instance, and its component parts. I'm not going to go through them all, the different variations. But they can all be boiled down to two key principles. The first is that any allegation of honesty just has to be well detailed. And the second is that allegation has to be put to the other side well in advance of any trial. The courts have since grappled with those principles and what they actually are supposed to mean, which I'll turn to in a moment. But I want to just briefly deal with now the burden of proof in fraud cases, because this has, according to the Supreme Court, been wildly misunderstood for years. This is the man responsible. This is Lynn Ungode Thomas. He was a Welsh Labour MP. He was a rugby player for the Leicester Tigers and an erstwhile Chancery Division judge. And what he said, he's credited with the maxim of the more serious the allegation, the more cogent the evidence needed to prove it. Turns out that's wrong in law. No fewer than 7 cases, including most recently from Baroness Hale, have said we have to put that phrase to bed. The position with the burden is actually twofold. First, it always has been, always will be, the burden of balance of probabilities. And the second is, the court can, in any case, consider the inherent probabilities of an allegation, but that bears no connection whatsoever to the seriousness of the allegations being made. That's a refresher on fraud. I'm now going to focus on the pleading requirements. These are the principles. They appear on the second page of that handout for those following along. And there's quite a few. And they're a bit bland when we phrase them like that, but it turns out they all spell fake panic. So when pleading fraud, remember to fake panic. I'll take these in turn. The first three, professionalism, allegations, and facts, are trite. You will all be familiar with those. It's the later principles I'll focus on. So first, professionalism. We all know in this room what our professional requirements are. The Solicitor's Code of Conduct requires you to have clear instructions and reasonably credible material to advance any allegation of that nature. You can, however, have some latitude in that. You can take account of facts you think may come out during cross-examination, during disclosure, during trial. So it's not as strict a rule as may appear. Second, and it sounds ludicrous to say this, but you must specifically mention fraud. You cannot skirt around it. You cannot use vague synonyms like sham or deception. You must say the word you're intending to use at trial. Third, any facts of the dishonesty or the fraud has to be spelled out with pitiless clarity. If you have primary facts that go towards fraud, an expert's report, for instance, spell it out. That deals with the first three principles. Now we get into the more technical issues. And the fourth is inferences. It's common for pleadings to invite a court to infer dishonesty from various different facts. Where you are relying on an inference, you must list those facts. You must set them out in a separate paragraph. That's not only been repeated several times by the High Court, but it's also in the specialist Commercial Court Guide, Queen's Bench Division Guide. Those facts that you put in the list, they don't have to all point towards dishonesty. They can point towards negligence, for instance. But that list that you have included has to tilt the balance of the case towards dishonesty. A good example of this was a case from late last year called Kasim and Mr. Justice Saini. It was a Clin Neg case in which the defendants alleged deceit on the claimant's part. The pleadings were pretty poor, and the claimant sought to strike out the defense. The defendant's counsel understandably argued that the defense is not supposed to be a checklist of facts. And if it was that, it would tip off any witness to cross-examination. Mr. Justice Saini gave short shrift to that, was not impressed. He said that flew in the face of the basic principles of alleging fraud, and he went out of his way to particularly criticize the fact of using the phrase, for example, or among other matters in the defense when listing those facts. The defense in that case was understandably struck out because they didn't list what they were saying and alleging in that case. Fifth principle is explanation. This sits side by side with inferences, and for good reason. Not only must you list the facts you're relying upon, but you must explain why that collection of facts amounts to fraud or dishonesty. In another case from last year, from Mrs. Justice Cockrell, the claimant included the list, so tick that box, but then failed to go on to explain in another paragraph how that body of facts amounted to fraud. The judge said in that case it was wrong to compile a vast array of different, apparently trivial and marginally suspicious facts without going further to explain the basis on which they turn the case into one of fraud. So, fourth and fifth principles, list your facts and explain why they are all there. Sixth, knowledge. It's not sufficient in any case to simply include a sentence or a paragraph which says that the defendant knew or ought to have known at the material time that they were acting dishonestly. That's not enough. If you read, however, the White Book commentary, you'll see a 1999 case of Rigby, in which it was said, that is enough. Now, I say with confidence that it's not, because almost every commentary on this topic says that Rigby is wrong. Indeed, CPR Practice Direction 16, which I'm sure you'll all be familiar with, says you must plead the basis for saying that the defendant or the claimant had knowledge of a particular fact. And that postdates the case of Rigby. So what you must do is spell out why the fraudster in the case had the knowledge you say they did. Seventh principle, dishonesty. Dishonesty is not what we once knew it to be. I'm sure you'll all remember from your law degree days a case of Gauche and the case of Twin Sector. They both said you have to consider the subjective elements in a fraud case and an objective consideration of the case. They're now complete rubbish. The Court of Appeal recently described change. They described it this way. They said the tectonic plates of the legal firmament have now shifted because we no longer consider a subjective test in dishonesty cases. It's purely objective. The test is now whether, if by ordinary standards a person's mental state is dishonest, then it is dishonest. It is entirely irrelevant what they thought they were doing and whether they thought they were acting in an honest way. So where does that take us with pleadings? Well, the principle now requires us to plead what a reasonable person would do. And I'm not encouraging referring to that trite phrase, the Clapham omnibus, but I'm sure in almost every case going forward, that will be mentioned in closing submissions. Eighth, we have names, and this is a curious one. We will commonly see allegations against a company acting dishonestly. And of course, companies can't. It's their officers, their directors, their employees who are acting dishonestly. When you are drafting particulars, you might not know their names. And it's okay to leave their individual names out. But as soon as you become aware of the individuals who are responsible for leading that company or body corporate to dishonesty, you must amend your pleadings and include it. Ninth, alternatives. There is nothing wrong with pleading fraud with a lesser charge, such as negligence. If you are going to do that, fraud must be first on the document and negligence must be second. It would be prudent in every case where you think it's on the balance to carefully review whether the inferences you are trying to draw are more consistent with negligence. If they are, or if there's any ambiguity, leave fraud out. Finally, concision. Be concise. Those are the 10 principles. That is the fake panic doctrine. Summary disposal, final area. And I'll say very briefly 2 things about this. In any strikeout action, the focus is not on the evidence. The focus is purely on the pleadings. The question for the court will be whether those facts that you have listed justify the cause of action, not whether they will go on to prove it. That's the first principle. The second principle is that there is now clearly a trend of the courts affording some leeway to claimants and some generosity, as they describe it, when alleging fraud in the more complicated cases. Fraud is becoming more and more clever. People are more astute. We have different variations of fraud: commercial fraud, digital fraud, online, things we haven't seen before. And it's difficult sometimes to encapsulate that in a 25-page particulars of claim. So the courts are more willing to afford some leeway at the outset of a case, but will invite claimants and defendants to amend their pleadings as cases progress. Conclusions. Fraud is everywhere. It's endemic. We just don't like saying the phrase. It's this reticence that we have, and we have to shed it. But we can't do that at the expense of the principles I've already outlined. Thank you very much.